Hello everyone, welcome back to my channel. So today we are going to discuss the provisions related to Register. Firstly, what is Register? Register in simple terms would mean the spontaneous statements which we speak when we are in a adrenaline rush or at that moment when we are excited because of emotions such as fear, anxiety, happiness, or some other. Because at the time of speaking the statements, we are in a sudden surge of emotions. These guarantee to have the sincerity which is required to be admissible in the courts. These are one of the exception of the Rule 60, which is about the hearsay evidence and their admissibility. So let's start with the relevancy of facts, the chapter 2. Evidence may be given of the facts in issue and relevant facts. The evidence would be given about such other proceedings or the existence and non-existence of the facts which are herein declared relevant and no other. So here it means that whatsoever the facts would be there which are admissible in the court should be relevant and directly related to what the court is trying to point out. They should not be irrelevant in such matter. This section shall not enable the person to give evidence of the facts which he is just entitled at the time being in force. For example, A tries to murder B by beating with a club, of which he intended to cause death. However, here we cannot say or ask A what he had for lunch, whether he had taken bath or was it a birthday of A at the day, as these are all not so important or directly related to what the facts are. So the court only allows those questions to be asked which are directly related to the offense and the crime. Next is the idea of res gestae, which is a legal maxim for the relevance of the facts forming a part of the same transaction. So here it says facts which are though not an issue are so connected with the facts in the issue that they are forming the part of the same transaction and are so relevant that whether they occur at the same time of the place or the different time of the place. So here we say that these are so well connected with each other that the presence or the relevance of the particular case, event, or the remarks which they constitute are very important and are constituting a part which can actually be admissible in the court of law. All those facts or the issues are known as the part of the transaction and res gestae. Now next is facts which are occasion, cause, or if an effect of the facts in issue. The occasion, cause, or effect of the issues which are relevant should be somewhat those which are facts in issue or constitute a state of things which has happened or which affords the opportunity to have occurred when the relevant transaction took place. So here again we have R versus Richardson case wherein the person ravished a woman while he was out of the office, and afterwards, after the ravishment, he killed the woman and left her to a place in dense forest. So all the occasions of getting out of the office, ravishing the women, and then thereafter killing her, all forms the part of the transaction, which are related to the occasion, cause, and effect of what the person has done. Motive, preparation, and previous or subsequent conduct. Any fact which establishes, shows, or constitutes the motive or preparation for any fact in issue or relevant fact, the conduct, the parties, or of the agents, the party, or the suit, proceeding irrelevance of such facts an issue, the issues which are related directly to the circumstances would be considered while examining the facts. The word conduct in this section does not include the statements unless those statements are accompanied or explaining the act other than the statements, but this explanation is not to affect the relevancy of the statements under any other section. So, the conduct of the person is relevant. Any statement made to him or in the presence or the hearing would be relevant. For example, the question is whether A robbed B. The fact that B was robbed and C said in A's presence the police was coming and looking at the robber B is immediately afterwards A ran away. And all these facts are actually relevant and admissible. So these form the part of the same transaction and are constituted as res gestae. A tries A is tried for the murder of B and he was found that he was having a poison which was used to kill A. So here in the circumstances that B is having the possession of the poison which killed A would be relevant and admissible in the court of law. So all these would be the relevant facts connected to the same issue. Facts necessary to explain or introduce the facts. So here it is talking about the test identification parade, which is about the identity of the person, which would be liable or prosecuted in the court of law. Facts necessary to explain the or to introduce the facts or relevant facts, or which supports or rebuts the inference which is drawn. For the time being, the facts at the end of the transaction which are relevant and necessary for that purpose. So all these would be admissible in the court of law. Things said or done by the conspirator in reference to the common design. Now, when there are reasonable grounds to believe that two or more persons have conspired together to commit an offense, or the action were wrong, or said that they done something, and the common intention is there, then the facts which are showing the relevancy, the conspirators would be admissible. For example, in the case of Mirza Akbar versus Emperor, the occasion of two lovers exchanging to kill C would be relevant and admissible in the court of law, as they form the part of the same transaction, as well as they here there are two people who are conspiring to do a certain act, that is to kill C. In this case, they should be read with the criminal conspiracy, which is section 120A of Indian Penal Code for better understanding. Now we have the plea of alibi. When facts not otherwise relevant becomes relevant. However, this says that if there is some inconsistency with the facts and issue or the relevant facts, the circumstances or the circumventing things which took place at that moment would also be considered in this case. If by themselves or in connection with other facts, making the existence or non-existence of the facts or facts and issue the relevant facts, and it is improbable these circumstances took place, then the circumstances surrounding the actual offense would also be considered to know the damage, know the type of thing which was in connection and why the person committed a certain offense. For example, in Nanavati's case, we see that looking at the women, that was the wife of the person who was a captain, and in a compromising place with this certain other men, or to be precise, the brother. The person was very ravished. He was raised and he took a gun and pointed it towards the brother of the man so as to kill him. Here the provocation and the surrounding circumstances which lead him to cause the death would be relevant, and they would be so connected to the issue. In suit for the damages or the facts enable the courts to detect, determine the amount of the relevancy. The amount of claim which is to be given, the amount of damages would be known by the amount of damage which is caused by that party. Facts relevant when rights or customs are in questions. So all the customs and all the traditions, whatever so would be there in a transaction which is recognized, claimed, or created, modified, recognized, ascertained, denied, or the customs which are consistent about that would taken into relevance. Particular instances of the claims recognized, exercised,